Hi everybody, good morning and happy Saturday. My name is Meghan Maes and this is Being Civil in Minnesota. I'd like to welcome everybody here on Saturdays at 10 where I can give information and resources about the rules in the state of Minnesota with regards to court cases. I am a family law attorney and a crime victim advocate. I do represent individuals, but this today is not intended to be legal advice. This is information. I want to make sure people are getting the right information out there, so that's what this place is for. If you or someone you know has a question or is going through a tough family law case and they have questions, you can join the group Being Civil in Minnesota and you can post anonymously your questions. I answer them Saturdays at 10. So took a break from last week. I just got back from spring break with kiddos. My husband and I took our 5 kids out of the country. First time with all 7 of us together. Parenting in another country is no joke. But all fingers, all toes returned, and hopefully a lot of memories. So back at it here in the new office. We had a question about if there is a custodial parent who lives in Iowa and they no longer want to have the majority of custody to be the custodial parent with the child, and they want to let the child go live with the other parent who lives in Minnesota. Their question was, well, how can they do that? So again, disclaimer, I am not licensed to practice in the state of Iowa. This information and these rules are Minnesota specific. So initially, there is a Uniform Child Custody and Jurisdiction Act, and that talks about having a court who's going to make an initial custody determination. So where there's been no court order before, when it's the initial time, typically the rule, at least for Minnesota, is in order to have a court hear your case in Minnesota regarding custody, the kiddos have to be residing in Minnesota for 6 months before the action is commenced. So while Minnesota doesn't have a time requirement for filing a divorce, Minnesota does have a time requirement for establishing custody and parenting time. And that is 6 months typically. There are some exceptions. So that is which state has jurisdiction to hear it. So in this case, it sounds like Iowa had the original jurisdiction and there is a court order in that state. Venue is a little bit different. Venue is which county the case is going to be heard in. And typically that's going to be where the parents live. And so I'm imagining that at one point somebody lived in Iowa. In this case, mom still does live in Iowa and was likely residing in that county when this case was started. So this parent wants to know, well, there's still another parent that lives in Iowa. What can I do? So if this case were in Minnesota and somebody came to me and was like, I live in Michigan now, mom would like to give me custody. There's a case in Blue Earth County, and so what do we do? The easiest route is, since it sounds like everybody's in agreement, would be to put together something called a stipulation, an agreement, something that modifies the prior court order and that is put in your court file so that there can't be any questions about, oh, this was just temporary, or I didn't actually mean it was going to be permanent, or I never said that. You want to make sure that things are put in the court file that you want to be enforced. That's very important. So if the case were venued in Minnesota, I would draft a agreement between the parties. If the other parent is not represented, I would have them do a waiver of attorney, or they could certainly hire their own attorney to review the agreement. Again, sounds like there's an agreement. Somebody posted on Being Civil, thanks Adam, he said that in his experience you have to go back to the original county where the order was issued, and that's generally where you're going to see most cases continuing, is in that original county. However, you can transfer a case out of the state of Minnesota if everybody agrees, and if nobody still lives in the state. So the reason why this act is helpful for some families is that it provides continuity. Locally, and I think it's probably a standard practice for most courts, is that for a family law case, you'd prefer to have one judge for one family. Oftentimes judges get just a very small snippet of what this relationship is like, and if there are changing dynamics and circumstances over time, that judge is going to have the best information and history and background in order to help this family the best that they can. So typically, one judge, one family. There are, like I said, some exceptions if there's an emergency. Now, just because there's an emergency doesn't mean that you would get to just say, okay, there's an emergency, I'm filing in Minnesota, and I'm just going to ignore Iowa forever. It's not how it works. Yes, there are certain circumstances in which a non-home state will step in, but they are generally always going to want to kick it back to the original state that issued the order to make a final determination. So they may put in a stopgap or sort of an interim kind of protection order, and that is allowed. And that's allowed in cases where there is abuse, or cases where a child has been abandoned, and in cases where a kiddo cannot receive gender-affirming care. Those can be very complicated. I would not suggest filing emergency requests for a state to take jurisdiction. It is not a common issue that judges see. Well, it's less frequent than you would think. So easiest route, go back to your court with an agreement, and then if you guys decide that you want to transfer the case to a different state, there is a rule that allows both judges to confer and speak about the case and where maybe more evidence is located or more information. If all of the witnesses and evidence regarding this family and what it's like to be a part of this family are still in the other state, it's hard to get a court to transfer that without good reason or one of the exceptions. So, thank you for posting this question. I hope you guys have a great Saturday. If you have questions for next week, please post them. Anyone who is still listening to this and has experience with doing these kind of live videos, Facebook has now, they're going to be deleting all the live videos after 30 days. So I've been saving them, and I will upload them, of course. But if anyone can help me with this headache, please shoot me a message on Being Civil in Minnesota. All right, enjoy, take care, we'll see you next week.